hearing there, the singular is actually correct, Advocate Johnson.
Police services.
No,
It's
the
services,
service
correct.
singular is correct.
Thank you.
Thank you.
Paragraph 5. The notice requires me to deal with the following issues on which Lieutenant General Lt Gen Khumalo testified. 5.1. That IDAC allegedly and unlawfully operates outside of its mandate in terms of Section 71A of the NPA Act as amended. And 5.2. That IDAC has allegedly pursued a criminal case against Lieutenant General Kumalo and other officials at Crime Intelligence in the furtherance of ongoing political interference in SAPS. 6. I deal with the issues identified above later in this affidavit. Before I do so, there are various issues I need to deal with if my answers to the issues above are to be sensible. Thus, I have structured the affidavit as follows. 6.1. First, I deal with the mandate of IDAC. 6.2. Second, I introduce the charges against Lieutenant General Samuel Dumisani Kumalo, in brackets, Lieutenant General Kumalo, close brackets, and others. 6.3. Third, I deal with the arrest of Lieutenant General Khumalo. 6.4. Fourth, I establish the relationship between the charges faced by Lieutenant General Khumalo and the mandate of IDAC, and then answer the questions that have been referred to me. And fifth, I conclude. Apologies. We turn to A, the mandate of IDAC. Paragraph 7. IDAC is a creature of statute. It is founded in terms of Section 7(1) capital A of the NPA Act as amended. 8. It is mandated to investigate, carry out any functions incidental to investigations. These are set out in 7(1) capital A close brackets of the NPA Act as amended. They are investigations, small a, relating to serious, high-profile or complex corruption, commercial or financial crime cases. Sub 1, arising from the recommendations of commissions of inquiry. 2, referred to the investigating director by the national director in terms of Section 28(1)(b, or 3, referred to the investigating director in terms of Section 27, subject to Section 26(2). Paragraph B, relating to additional related offenses or categories of offenses, including common law offenses of 1, fraud, 2, forgery, 3, uttering, 4, theft, and 5, any offense involving dishonesty. Paragraph C, relating to additional related statutory offenses or categories of statutory offenses, including contraventions of 1, the Prevention and Combating of Corrupt Activities Act 2004, that's Act number 12 of 2004. 2, the Prevention of the Organized Crime Act 1998, in brackets, Act number 121 of 1998, close brackets. 3, the Protection of Constitutional Democracy against Terrorist and Related Activities of 2004, that being Act number 33 of 2004. 4, the Public Finance Management Act of 1999, that being Act number 1 of 1999. 5, the Local Government Municipal Financial Management Act 2003, that being Act number 56 of 2003. 4, the Financial Intelligence Center Act 2001, that being Act number 38 of 2001. And 7, any other statutory offense involving dishonesty, and D, where appropriate, institute criminal proceedings and carry out any necessary functions incidental to instituting criminal proceedings relating to any offense contemplated in paragraphs A to C.
This may not necessarily be of relevance to what we are inquiring into, but I'm interested to know how you read the or between high profile and complex corruption in paragraph A of the section. How do you read that or? Do you read it literally as or, which would be problematic, or do you read it as and, which would also still be problematic? If it's the former, it would be problematic to investigate cases purely because they are high profile, even if they are not serious. But at the same time, if you read it as and, the problem there would be a case can be high profile, but not necessarily serious. I don't know whether it's an interpretative exercise that you've ever bothered to look into.
Chair, if I'm in the right place, we are referring to paragraph A?
Yes, A.
Relating to serious, high profile, or complex corruption, commercial or financial crime cases.
Or the high profile goes with the serious that comes before.
It goes with the serious that comes before.
But what if it's not high profile?
Then
it may be serious but not high profile.
Then it remains as serious or complex corruption, commercial.
Anyway, let's not bother it. It's something that has exercised my mind, and
I appreciate that.
Yeah. All right. Thank you.
Advocate Johnson.
Sorry.
Good morning.
Morning.
In similar vein, can I just ask, how do you read B and C, which this part, relating to additional related offenses, and this similar wording in C, do you read them to have any relationship with A, with what is specified in A, or you read and operate on the basis?
Self-standing offenses in addition to.
Just to make sure I understand, so you can investigate, or you do investigate a case of fraud, even if it's not a serious, high-profile, complex corruption, commercial or financial
That is
matter.
correct.
Thank you.
Another problem that was raised by my colleague Commissioner Baloyi with Colonel Padayachi relates to the concept of specified offense, which appears a number of times in the Act. And it's supposed to be a defined term in accordance with Section 1. But what would have assisted with a definition, which is what was a subsection 1 in whatever the relevant section is, 7.1. It would have been a 7.1. That's been repealed, it's deleted, and you see ... there, which effectively means that there's no definition of what a specified offense is, and yet the Act is replete with references to specified offense, which suggests that there may be a problem there as well. I don't know whether this is something that the NPA has ever applied its mind to, or are we perhaps misreading the Act?
The 7.1, in terms of the specified offences, was deleted, and we have the 7.1A. And we did raise that seems to have been an error in deletion. It was an error by the legislation. And the specified offences should not have been deleted. But
Yes,
we're
yes.
working
But
on what we have.
Yeah, for completeness on what I said, here's the definition in section 1, the definition of specified offense. Specified offense means any matter which, in the opinion of the head of the investigating directorate, falls within the range of matters as contemplated in section 7.1, and then it goes on. Then you go to 7.1 expecting what's
Specified.
Yeah, that cross-referencing to have a meaning or to complete the definition. When you go to 7, and then there is indeed the 1, the bracketed 1, but then the ... I referred to, the effect of which is that the definition is incomplete. Yeah.
It is.
So I think that's something that the NPA needs to address and have, or rather attend to, or initiate an amendment to the Act. Anyway.
I take note, Chair.
Yes.
Can I just follow up on this? The deletion is in August 2024. Since then, and you say there's been a recognition that it was a mistake, has there been any moves afoot to legislate it back into the Act, the deleted part, in whatever form? Is there anything happening there?
Commissioner Baloy, may I come back with that response, because it is dealt with by a separate legislative section in the NPA,
Okay.
and when we do find shortcomings, we do escalate to them for their engagements with the Department of Justice.
All right, you can
I'd
come
rather
back
give
on
you a
that.
correct answer.
All right, thank you.
Thank you,
Ms.
Commissioners.
Ms.
You may proceed with your statement, Advocate.
Paragraph 9, having identified the mandate of IDAC, I now turn to the charges against Lt Gen Khumalo and co-accused. Capital B, the charges against Lt Gen SD Kumalo. Paragraph 10, a charge sheet is a public document. Thus, as opposed to regurgitating its content, I should do no less or more than to refer the Commission to the charge sheet. A true copy of his charge sheet is attached here too and marked AJ1. Paragraph 11. The charge sheet concerns not only Lt Gen Khumalo, but his co-accused as well. In the charge sheet, I emphasize and draw the attention of the Commission to the charges which each of the accused persons, Lt Gen Khumalo in particular, is facing. The Commission will note that they are facing, among others, 11.1, contraventions of the provisions of Section 4A of the Prevention and Combating of Corrupt Activities Act, 12 of 2004. 11.2, contraventions of the provisions of Section 4B of the Prevention and Combating of Corrupt Activities Act, again 12 of 2004. And 11.3, fraud and other related offenses. Paragraph C, the arrest of Lt Gen Khumalo. The evidence before this Commission is that Lt Gen Khumalo was arrested in a dramatic fashion. Nothing can be further from the truth. It is important that I address this aspect as well. Paragraph 13. Lt Gen Khumalo was arrested on 26 June 2025 at Oliver Reginald Tambo International Airport, OTIA. Only 2 senior criminal investigators in IDAC, senior criminal investigators within IDAC, were tasked with the exercise and effected his arrest. It was Mr. Sunil Belochan and Ayan Dambalo, in brackets, the investigators. If I may then pause here,
Yes.
Commissioners, and Advocate Sello, to go to the last statement, statement number 3.
You deal with that correction?
So paragraph 14, as it reads in the original.
Before we do so,
Sorry.
what do you suggest? Are you going to amend some parts of that paragraph, of the current paragraph 14 of the main statement, or are you proposing an entire deletion of that paragraph and substitution?
An entire deletion of that paragraph, as well as paragraph 15.
Thank you.
Because they should read correctly, and as they currently stand in the original affidavit, they do not read correctly.
Okay, then let's deal with the first.
Paragraph 14 of the original affidavit to be deleted and to read as it does in paragraph 10.1 of the third statement. I say in 10.1, paragraph 14 must be replaced and should read as follows. Lieutenant General Khumalo was arrested after he had landed at the Oliver Reginald Tambo International Airport, OTIA. I do not recall where he was traveling from. I was informed that, at the time, his co-accused had already been invited to report to the Brooklyn police station. That is the correction.
Noted. Thank
I
you.
therefore ask as well that paragraph 15 of the original affidavit, Commissioners, be deleted and to read as it does in paragraph 10.2 of the last affidavit, wherein I state paragraph 15 must be replaced and should read as follows. The investigators went to OTIA to inform General Kumalo that there was a warrant for his arrest and for him to hand himself over. They had a warrant of arrest for him. Warrants of arrest had also been sought and obtained for his co-accused before they were requested to hand themselves over at the Brooklyn SEPS. Those are the corrections, Commissioners, to paragraphs 14 and 15 of the original affidavit.
Noted. Thank you. We may proceed, I think, with your statement.
If I could just have some water. Thank you. Paragraph 16. Upon finding him at OTIA, the 2 investigators explained who they were, why they were there, why he was sought, and what his rights were. They then asked Lieutenant General S.D. Kumalo to accompany them to Brooklyn Police Station in Pretoria. He cooperated and was taken there. There was nothing dramatic about it. 17. At all times during his arrest, Lieutenant General Khumalo's security detail was with him. He was not threatened and was accorded all the respect that could be accorded a person of his profile. On the way from Orchard to Brooklyn Police Station, the investigators had occasion to stop and get something to drink from a filling station at the request of Lieutenant General Khumalo for himself. Paragraph 18. Once Lieutenant General Khumalo had been processed at Brooklyn Police Station, he personally thanked Chief Investigator Perumal for treating him and the other co-accused in a respectful and dignified manner. This talks to anything but the conduct of a unit that is motivated by ulterior motives other than to address alleged criminality. Paragraph 19. I would be remiss if I do not dismiss the suggestion that Lieutenant General Khumalo was arrested because he was the coordinator of the political killings task team in brackets PKTT. This suggestion is anything but true. It is false as it is unfortunate. The truth is that IDAC was investigating Lieutenant General Khumalo in his capacity as the Divisional Commissioner of Crime Intelligence for alleged unlawful conduct that manifested itself in the execution of his duties in that capacity. Paragraph 20. The fact that Lieutenant General Khumalo also held another portfolio in relation to the PKTT was not within our knowledge. At no stage was I, as the head of IDAC, aware that Lieutenant General Khumalo had anything to do with the PKTT, let alone being its convener. In any event, even had I been aware of same, such would have been irrelevant because of the reasons for his arrest. I have attached it to this affidavit and therefore placed his charge sheet at the disposal of this commission. Paragraph D. The charges fall within the mandate of the IDAC. 21. The allegations concerning Lieutenant General Kumalo and co-accused came to the attention of IDAC by way of a referral that was made in terms of Section 27 of the NPA Act. 22. Section 27 of the NPA Act provides that, quote, if any person has reasonable grounds to suspect that a specified offense has been or is being committed, or that an attempt has been made or is being made to commit such an offense, he or she may report the matter in question to the head of an investigating directorate by means of an affidavit or affirmed declaration specifying A, the nature of the suspicion, B, the grounds on which the suspicion is based, and C, all other relevant information known to the declarant, close quote. Paragraph 23. The referral was made by Mr. Fadiel Adams, in brackets Mr. Adams. It was not treated any differently. It was supervised and overseen like any other.
What do you mean by supervised and overseen?
When a Section 27 matter comes in, they sometimes come directly to the office of the investigating director, or the investigating directorate has a head of operations, which is Mr. Matthew Sissoko, and Section 27s may go there. The matters are considered either first by the ID, but given that these matters may be voluminous, my office almost invariably refers them to Mr. Sissoko for his perusal of the matter and for a summation on whether or not it falls within the IDAC mandate. He will then bring the entire matter to myself for me to then peruse the matter, consider his recommendation. If the matter falls within the mandate of IDAC, that matter is then, commissioners, allocated to a team. And when I say team, there are various teams in IDAC led by deputy directors of public prosecutions and then comprising advocates and prosecutors of different ranks, criminal and financial investigators, and project managers. And they then will take this matter, consider it, and then bring an application where they agree that it falls within the mandate of IDAC as per what we have suggested, an application for an authorization for an investigation. That comes out of the team to whom the matter is referred.
Oh, so there are what? Is Mr. Sissoko also an advocate?
Mr. Sissoko is an investigator.
Investigator?
Yes.
Oh, right.
So
right.
what it does do is I have an investigator who looks at it, and then me as the investigating director and being the advocate we have a more holistic view, having two sides to it. So whilst that final decision may rest with my office, it has been more practical to have his view and his insight, and then the final decisions that do come out of the Office of the ID.
So your decision that there should be an investigation always comes after a recommendation has been made by the
Mr.
level of...
Sissoko.
No, I thought you said it's Mr. Sissoko. Mr. Sissoko comes to you. From you, it goes to, I thought, maybe more than one person who then come back to you.
No, sir.
All right.
It would come to me.
Yes.
Go to Mr. Sissoko. Once
Yes.
he comes back and it is part of his recommendations that yes, it falls within the mandate, I myself go through the matter to either endorse that decision or where I disagree, we engage. After that, the 27 goes to a team who must...
For what purpose? It goes to, that's the team I was referring
Yes,
to just now.
that is
What does that team do? What does that team do?
That is the team that must now consider whether or not they can put together an application in terms of Section 28 for an authorization of an investigation into certain allegations that they would identify, offenses that they would identify, and persons of interest and or entities of interest that become known through the 27.
Lastly, hopefully, what is the nature of your decision when you refer to the team? What decision would you have taken at that stage?
At that stage,
Yes.
I would only refer it to a team where I do agree that this matter falls within the mandate of IDAC.
So oh, okay.
I do not give I just make a decision, it falls within the mandate. The matter then goes to them to dissect, to consider allegations, persons to be investigated, etc., for an authorization for the investigation.
I hope I'm not sounding like I'm probing at this stage. I just want to be clear in my mind as to what's going on at that stage. Can you refer us to the Act, perhaps? When you refer to the team, are you able to refer, in terms of what section in the Act you would be acting in referring to the team? And then also the team's involvement in terms of what section in the Act would the team be acting for it to do whatever it is they would then do or they would be doing?
Chair, this is it has been more of a practical consideration so that it is not the investigating director who makes decisions around who must be investigated, what must be investigated. They bring the application. The investigating director would then have to apply her mind to the application on what offenses, persons, etc., must then be investigated. That then becomes my decision or the investigating director's decision in terms of Section 28 of the Act. It's a practical step.
So that you are not able to slot that practical step into a juristic act authorized by the Act itself. I'm not saying it's unlawful just because you are not able to slot it into a particular section within the Act. I'm not suggesting that at all. I just wanted to understand its juristic nature.
It is a practical consideration.
All right, okay.
Can I just follow up on this? So when Colonel Padeachi speaks of a committee, he spoke of a committee, an intake committee, I think that's the word, and he said that committee is the committee that makes the decision whether you would take on that matter. From your description, that committee or that function that he was saying is of an intake committee, it's exactly what you say you and Mr. Sissoko get to do.
He is incorrect about a committee. These are, Chair, when you put to me about the juristic nature of things, after IDAC became permanent in August of 2024, we realized that there are certain processes that one would have to put in place. We have come up with a draft operations manual, very much like where the police have standard operating procedures. And it is in that draft operations manual, which is soon to be finalized, that you would find the suggestion of a committee. But there isn't, Commissioner Baloyi, a committee. I also do not consider myself or Mr. Sissoko a committee of any sort. It is, excuse me, in terms of the functions that we have and for practical reasons that we were able to do it that way.
Okay,
Thank you.
Advocate Johnson, please just clarify paragraph 23 in terms of the timeline. We had a witness here 2 weeks ago, Mr. O'Sullivan. In paragraph 1.8.3 of his witness statement, he takes credit for having referred this very case to IDAC, and he says it was in November. We also know from documents that we have that the minister's office also in November referred this very same case to IDAC. So for now, maybe we'll come back to those later. For now, which one came first? Which of the three came first? Was it Mr. O'Sullivan, or was it the minister, or was it Mr. Adams? So when it first came to you, which one did you look at first and then gave to the people below you who were supposed to look at it?
The one I looked at first was the one by Mr. Adams dated 21 November because it was the affidavit. I am unaware of any referral with regards to this matter from Mr. O'Sullivan. I do confirm that the minister's office did write a letter to us, but I cannot recall Mr. O'Sullivan being involved in this specific matter. I would, when we do go to his document, because I don't have, I know that we did look at the letter from Minister. I think it is dated the 11th or so of November.
Yes.
And then there's the referral by Mr. Adams dated the 21st of November, which is the 27th. I am unaware, Commissioners, in fairness, of any referral made by Mr. O'Sullivan. None